Hello, Attorney General Lisa Madigan. I would like you to answer this question. How does a citizen lawfully exercise their inalienable, enumerated, fundamental, individual, incorporated right to keep and bear arms here in Illinois?
You can't. Doing so is a violation of the Criminal Code of 1961 and you will be prosecuted.
Didn't the Supreme Court decide against your position in the Heller v. D.C. case 3 years ago?
Yes. But that doesn't matter because the Bill of Rights, the Constitution it is a part of, doesn't apply here in Illinois to state and local governments.
Wait a second. Didn't the Supreme Court decide against your position again a year ago in the McDonald v. Chicago case?
Yes. But I will say this again to you. I agree that Illinois or municipal laws banning open/concealed guns outside of the home are still in effect. Whether they remain so will be the subject of years of future legal challenges, but until a court says otherwise, people need to respect those prohibitions.
Are you saying that law has to be made within the courts? The Constitution for these United States says that lawmaking powers are delegated to the legislative branch of a Republican form of government, not the judiciary. So how can you say that and remain honest?
You see, it is called case law, and it is indeed created in the courts because the justices interpreted it to be so. The court sets precedent. You would have to attend an Ivy League law school and gain a degree to hang on the wall in order to understand. It is complicated.
But isn't that exactly what the Supreme Court did in the Heller and McDonald decisions? Didn't it set new precedents in both of them?
Well, yes, but that only applies to people within their own home, and you still must have a FOID card in your possession at all times or you will be prosecuted.
Prosecuted? For what? And if that is true, how would a homeless person exercise their creator-endowed right to keep and bear, to own and carry firearms?
You will be prosecuted for violation of the FOID Act. The legislature, the Illinois General Assembly, has commanded you, as subject to the police power, to apply for permission to purchase and own firearms and ammunition. It will cost you $10.
So if I pay for a permission slip called a FOID card, I can carry my handgun in case of confrontation so that I can defend myself? That sounds a lot like a poll tax. How can the state of Illinois charge someone to exercise their rights?
No, the FOID card only permits you to purchase, own and be in possession of firearms that are unloaded and fully enclosed in a case. You cannot carry a firearm anywhere except within your own home. Poll tax or not, the General Assembly, which is dominated by Chicago Democrats, has commanded you to comply. You will be prosecuted if you fail to do so.
I ask you again, then how would a homeless person exercise these rights? And isn't it your job to defend the civil rights belonging to the citizens of Illinois?
You will have to take those questions to the Illinois General Assembly. Try talking to my daddy, he is the Speaker of the House.
Thousands upon thousands of people try to do that very thing, every year, around the beginning of March, during an event called IGOLD, Illinois Gun Owner Lobby Day, but your daddy, Michael Madigan, is nowhere to be found. He and the rest of the gun-grabbing Chicago Democrats run and hide, putting up their human shields, called staffers, to take the heat for them. Legislation that Republican representatives propose is sent to the Rules Committee to die, so Michael Madigan can facilitate his refusal to allow up or down votes on those bills he disagrees with. How democratic of him.
You will have to associate with a lobbyist, who is backed by a large and rich organization, in order to gain access to my daddy. However, he despises and fears firearms as much as I do, and I doubt any organization has enough money or power or campaign donations to convince him to allow an up or down vote on legislation that would bring Illinois into compliance with the Second Amendment and the current case law concerning it. But even if you did manage to get a bill passed, Governor Quinn has already stated he will veto any legislation anyway. Sorry about your luck. Why do you think I told you it would be tied up in court for years and years?
Oh. You mean the governor who only won the majority vote in 3 counties out of 102? How can he decide if a right is really worth insisting upon on a case-by-case basis when Justice Scalia wrote that such power is taken out of the hands of government? For that matter, How can the General Assembly do so?
As Attorney General of Illinois, I give them both a free hand to do so. It is the Chicago way.
So you think we the people have to file a complaint for declaratory judgment in civil court in order to find relief and redress for this grievance? Isn't there an obvious Section 1983 violation of the Civil Rights Act here to be addressed?
I cannot offer legal advice to simple citizens. But good luck to you finding a member of the bar who will actually do that. They all know that not only will they have to take on the Chicago machine, headed up by me and my daddy, but the National Rifle Association will also muck up the program as much as possible. It knows how bread is buttered. Just ask Alan Gura.
So let me get this straight now. Illinois already has a permission slip called a FOID card that citizens have to pay for. But even with one of those permission slips, nobody can carry a firearm anywhere but within their own home. Homeless people be damned. In order to gain access to the Speaker of the People's House, we must operate through a lobbyist. Even when professional lobbyists make it fully known that thousands of people are coming to the Capitol, Michael Madigan will still run away. Even if a bill is passed, one that asks for a second permission slip that comes with even more costs and commands, the governor will veto it anyway. And Illinois' people will still reside in a state that stands alone as the only state in the country where its own citizens are 100% prohibited from exercising their Second Amendment rights and will be prosecuted if they dare exercise them. Do I have that right?
That is right.
So even if thousands and thousands of people come to beg for permission from government with the Heller decision in one hand and the McDonald decision in the other hand, you and the rest of Illinois' government will ignore our plea.
That is correct.
How can it be that Rush Limbaugh, Laura Ingraham, Glenn Beck, Sean Hannity, Mark Levin, and the rest of the famous conservatives with national microphones don't say anything about the situation here in Illinois? I mean seriously. Here we have the most egregious and far-reaching violation, total prohibition, of one of the most revered rights in this country's history, and these folks are silent. It really makes folks wonder how that can be.
We in Illinois government are deeply thankful for that silence. The last thing we need right now, amid the largest tax increase in Illinois history, is media attention focused on this policy. Their silence aids our efforts in denying people their rights.
I suppose you feel the same way about the silence of prominent print media writers as well then? You wouldn't want to see Thomas Sowell, Walter Williams, or Ann Coulter doing columns about this subject, would you?
Absolutely not. We in Illinois government like it a lot better when Ed Schultz, Rachel Maddow, Lawrence O'Donnell, Michael Moore, Oprah, and Eugene Robinson opine about the merits of denying people the right to keep and bear arms, unopposed. The emotion of the notion that it is for safety works well in the establishment media.
Back up. Didn't the Heller decision dismiss the premise called the freestanding interest balancing approach?
Yes, it did. But as I told you in the beginning, it is so very complicated. With so much silence and a lack of media focus, especially national media attention, we can string this out for years and years. There is nothing you can do about it. As I said, it is the Chicago way. Personally, I very much look forward to all the people coming annually to beg for permission to pay the state of Illinois to allow the exercise of their inalienable rights. The only thing I relish in more is watching gun advocacy groups convince their own supporters to do it. It demonstrates just how ignorant and uninformed the people of the state, Illinois, really are. And it puts me at ease while I eagerly await my eventual ascension to the throne called the governor's office. My daddy promised that to me long ago, and I fully intend upon assuming my place atop all the little people.
We shall see what the folks among the Liberty Movement have to say about that. 9/12ers and Tea Partiers are raising constitutional awareness more and more every day. Folks are figuring out that we already have a permission slip, and it reads like this: a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed.